Welcome, 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 everybody. It's the Monday edition of Talkback, brought to you by the Mustard Seed Asian Cafe in Southgate Mall, Kootenai Creek Village, the maintenance-free active adult community in Stevensville for the best of Western Montana living. Dig It Excavated, where they bring 30 years of excellence to every job. For all your excavation needs, call Glenn at 214-4292. Okay, here we are. Talk Back now. Health Talk is done. It's time for Talk Back. And that's John King over there.
And that's Peter Christian over there. And we have on the phone internationally renowned constitutional scholar Rob Natelson.
Wow.
Author of the original Constitution, what it actually said and meant.
But don't insult him because he might libels you.
Yeah, he might sue you if you call him short or angry or fierce or any of those things.
Internationally renowned. I guess I know some guy in Canada.
All right. One of the things we wanted to talk about today, Rob, was the fact that everybody's favorite around here seems to be Donald Trump. I know John just absolutely loves him, and he made a statement a week or so ago because so many people were just kicking him around. He was really tired of it. So let me just go ahead and play this so that Rob can hear it and everybody else can be reminded of what Donald Trump wants to do with your free speech.
Well, on the issue of libel, right?
Yes, issue of libel. Here we go. And people are cheering?
Yeah, we're going to sue you is always a... Don't you get that? Don't you just want to cheer when someone says, I'm going to sue you?
Yeah, I love that. So Rob, as an attorney and be a constitutional scholar, how do you feel about that?
It's hard to know where to begin. The depths of this man's ignorance seem to be, unfathomable. The first place, let's start with the first place. Open up the libel laws. What does that mean? I think what he means is that, and I can only speculate, is it would loosen up the libel laws so that, or enable people to sue on more grounds. He may not be aware of this, but libel laws are a state matter, not a federal matter, okay, for the most part. The libel laws originally were put into effect so that people would have an alternative to staging a duel when somebody insulted them. They could go to court instead and vindicate their good name. In 1964, the Supreme Court issued a case called New York Times versus Sullivan, which, on First Amendment grounds, constricted the extent to which people could use the libel laws, especially people in the public eye. And I disagree with that decision. I think by taking away the right of people who are in the public eye to sue for libel, it's coarsened our discourse. But other than appointing Supreme Court justices or promoting a constitutional amendment, the president's got no role in this. The other observation is, and it's an observation as a historian, not as a constitutional lawyer, is that this is real thuggery. I mean, threatening the press, threatening people who criticize you in the way that he did. It's incomprehensible to me that this guy's being as a viable candidate for dog catcher, much less president. But then again, I didn't think Obama or Hillary Clinton are viable candidates either.
Let me ask you something. Let's say we were on the air with someone, and there was a violent exchange between John and this person, or me and this person, and I really got after it and just was fairly offensive in my comments. Would that be slander because it's spoken, or would that be libel because it's publicly heard through the airwaves?
I think it would be libel because it goes through the airwaves. Slander is generally spoken in the personal presence of somebody. We tend to put libel and slander together, and we call it defamation law. Now, just a clarification here: if somebody goes around saying something false about you, and it causes you damage, and you're not a public figure, you've got as much right to sue and collect from him as you ever did. The 1964 opinion of the U.S. Supreme Court and the opinions that followed it have made it much more difficult for public figures like Donald Trump, for example, or when I was a public figure, me, to collect for libel. And again, I think that decision went too far. I think that public figures should have more of a right to sue for libel. But what the President of the United States can do about that, other than appointing justices, I don't know. Well, he can't unless he wants to use methods outside the law.
Well, can't he push the legislature to change the law?
Well, again, if he went to Congress and said, I want tougher libel laws, those libel laws would still be subject to Supreme Court restrictions. But in addition, libel is a state issue. I mean, I would hope that Republican voters would take into account the division of powers between the federal and the state government. I mean, we've had the federal government has taken over so much that is traditionally and constitutionally a matter of state jurisdiction. Do you want a Republican president standing up there and having the federal government assume power over yet another area of state concern, and that is the libel laws?
So, I guess I want to know why it's a state issue. The federal government, obviously, you can't. Free speech is in the Bill of Rights, right? So, if a state is infringing on free speech with too strict libel laws, then the federal government would step in through the Supreme Court, I assume.
That's right.
And say, knock it off.
And the federal government in the form of the Supreme Court has the authority, or at least has assumed the authority, to police state libel laws. But there's still state libel laws. So if you want to create in Montana an additional grounds on which to sue someone for libel, that can either be done by judicial opinion, which is the traditional way it's done, or it can be done by statute. But again, at the state level, and the role of the federal government through the Supreme Court is purely as a check to make sure that the libel law is not interfering with the First Amendment or the court's version of the First Amendment. Again, this is not the check is not for the president, and the passage of the laws itself are not for the president or for the federal government.
Okay, Rob, we're up against a break. A question I want you to answer when we come back is, let's say John Doe is running for office, all right? And the people who are opposed to John Doe and the other party find out, he's had 3 drunk driving convictions back when he was 17, 18, and 19 years old, and he's 55 now. There's all sorts of juicy stuff we can release on him to make people think he's a really bad guy. So I guess I would ask you, is that slanderous, is that libelous, or is it simply an inconvenient truth for the candidate? We'll come back and talk about that in a minute. Okay, we're back on Talkback. 721-1290 is our number, and it's sponsored in part by Transport Equipment, your headquarters for RV service maintenance and repair. Call 541-9097. And by Bulls Eyewear, they offer some of the lowest prices in town on contact lenses. See Lynette at 2910 South Reserve. Our guest on the phone from the Independence Institute, Rob Natelson. And Rob, I asked a question before the break. Let's say John Doe is a candidate for public office in his 50s. And somebody doing some research finds out, you had a couple of DUIs when you were in high school or in college, back when you were 18, 19 years old. I'm going to use that against you to show that you have bad character. So is that slander, is that libel, or just an inconvenient truth?
In this country, it's always been an inconvenient truth. In this country, truth is an absolute defense to a libel suit. Back in Britain, there were some cases, not in all cases, but there were some cases in which you could not say certain things in the newspaper, even if they were true, because if you had something that was incriminating on somebody, you had to go to the prosecutor instead. But in this country, truth has always been a defense. The question of defamation, a more interesting question, arises when you make allegations about someone that are not true. And if you are defamed in that way and you're a private citizen, you may very well have the power to collect damages against the person who said what was not true about you, if, for example, that person was negligent in making the charge. If you're a public figure, on the other hand, it's very difficult to win a lawsuit against somebody, even if what he's saying is untrue. You have to demonstrate that he knew it was untrue or proceeded with reckless disregard as to whether it was true or untrue, and that's very difficult to do. The only public figure I know who ever successfully carried that burden was Barry Goldwater.
Now, is that what absence of malice is all about?
Yes, malice. What is called for historic reasons actual malice in a civil case, not a criminal case. Actual malice means you either knew what you said was false, or you proceeded in reckless disregard for whether it was true or false at all.
Wow.
And to illustrate the point, in 1964, a smut peddler named Ralph Ginsburg put out a, quote, newspaper, end quote, which claimed that Barry Goldwater, who was then running for president on the Republican ticket, was psychologically unfit for the job, and that something like 1,700 psychiatrists had claimed that he was unfit for the job. Goldwater, after losing, sued Ginsburg for libel, and he won the case. He was able to demonstrate that Ginsburg made some of the quotes up, suppressed quotes on the other side, altered quotes in various ways, all with the idea of smearing Barry Goldwater. However, in addition to proving that the allegation is false and that it was made with actual malice, you also have to prove damages. Goldwater had lost the election and was unable to come up with witnesses who said that they believed this article or that it made any difference in their opinion. So the United States District Court awarded Goldwater actual damages of only $1.
Wow.
But it then went on to award $75,000, pretty big money in 1969. It awarded him $75,000 in punitive damages because of the outrageous way in which Ginsburg had acted.
I wanted to ask you a little bit about that issue of defamation. So it's my understanding that some people, like a serial killer or a child molester, that because they have no status to lose any fame from, because they have been immoral in their behaviors, that
say Joseph Edward Duncan would be a good one.
They are at a point in their lives where you can't really defame them, that you could say anything about them and it wouldn't ruin their character.
Well, yeah, that's a good point. I mean, as the Goldwater case illustrates, you have to demonstrate actual damage. Every witness they put on the stand said, I admire Barry Goldwater or I don't admire Barry Goldwater, and when they were asked whether the magazine article or the newspaper article had changed their opinion of Goldwater, the answer was no. The people who didn't like him before or after, and the people who did like him, the smear didn't make any difference. So that's why he was unable to recover actual damages.
I wanted to step back to something you had said earlier, that you thought that the 1960s decision, which I can't remember the title of.
New York Times versus Sullivan.
Thank you. That particular decision coarsened the language in America.
Yeah.
And you had also mentioned many times throughout this discussion that Europe and England specifically have a little bit stricter libel laws. What did we have at the original founding, and what do you think we should have now?
Well, I didn't make a statement about England today. I said that back in the early, specifically in the early 18th century, under some circumstances, even truth couldn't protect you from a damage award or even a criminal prosecution for libel. That's never been true in this country. Traditionally, the rule in this country has varied from state to state. It's a state issue. One of the things that the founders were very clear about is that the law of torts, the law of personal injuries, except in a few narrow cases involving things like interstate commerce, that would be a reserved state power. And to a considerable extent, it remains a reserved state power even today. I suppose the election of a President Trump might result in even that area of state jurisdiction being preempted by the federal government.
Well, we are done with this segment, and I want to offer the phone lines to callers. You can give us a call at 721-1290. We already have a Facebook question from Josh. We'll read after the break. Give us a call. Get in the queue before it's too late.
We'll be right back. It is 9:20 on your Monday Talkback Show. We'll be right back. I'm Peter Christian, and we do have Candy on the line, so let's get right to the phones. Oh, we have a Facebook comment first. Go ahead.
We've got to turn my mic on first.
There you
Yeah,
go.
Josh posted a little while ago, so I want to read his first. Josh asked the question, does the Constitution codify slavery and forced prison labor?
Does it codify slavery and what?
Forced prison labor.
What the Constitution says is that neither slavery nor involuntary servitude, except for punishment of crime. What that means is that yes, it's constitutional to require prisoners to work. That never has been treated as slavery. I mean, slavery is defined in a different way. It's what they call involuntary servitude.
Okay, let's get to the phone. Candy, you're on Talk Back with Rob. Hi.
Hi, Rob. Good
Hi,
to
Candy.
hear your voice. I know you had mentioned that there would be challenges to Ted Cruz's birth and his citizenship. And I just came across some information that said he was born in Canada and he was born a citizen of Canada, and that his dad at the time was a citizen of Cuba, and his mother was from Delaware, and that Ted Cruz was not registered at birth as a citizen, and the only existing birth records are Canadian and not. She didn't register him as an American citizen. So there are no birth records other than he was a citizen of Canada and Cuba, dual citizen, and he didn't give up his citizenship in Canada until 2014. So where is that leading us as to his eligibility? Because it doesn't say he was naturalized. It has no information about his naturalization or anything. And
Okay.
I don't want to be caught in that gap again as we have the considerations of Obama.
Okay, thanks for the call, Candy.
Candy, this is a little bit technical. First, there's no question that Ted Cruz is a citizen of the United States. He is a citizen of the United States, and he has been a citizen of the United States since birth. No doubt about that. The reason we say that is because his mother was an American citizen, and even though he was born in a different country, by reason of congressional statute, he is a citizen. So there's no problem, for example, with him being a U.S. senator.
To say it simply,
the difficulty that he has is that the Constitution requires that the president not only be a citizen, but that he also be a natural-born citizen. And the doubts that I expressed were based upon how the founders defined the term natural-born citizen. At the time of the founding, a natural-born citizen is somebody who had been born in this country. Almost everybody who was born in this country was natural-born. There were a few exceptions. Or, if born abroad, were born to a citizen father. Mm-hmm. And while Ted Cruz's citizen mother is enough to give him citizenship by statute, whether it is enough to give him citizenship as natural-born is another question. In the way of full disclosure here, other scholars have taken the position that they think that Ted Cruz is natural-born. And, of course, there's no guarantee how the courts would rule. I think the concern I expressed on this show was that I'm not sure the Republican Party or the American people need that right now. They don't need that kind of doubt. Now, I hasten to say I have not endorsed any particular candidate. I am an admirer, a strong admirer of Ted Cruz, but this is a concerning issue. And ignoring it, as I think the Cruz campaign has largely been doing, is not going to make it go away.
Okay, now, Rob, here's my question for you. Before anyone can file to become president of the United States to run for office, doesn't the Federal Election Commission have to say, well, we don't think you're a citizen? I mean, couldn't they have cut that off at the pass?
No. What happens is that people file for the primary elections in each state. So, for example, there has been litigation going on in Illinois, and I guess Cruz wanted dismissal on a non-substantive, a technical ground. But there's litigation going on in several different states right now regarding his placement on the ballot. At the time, and again, the concern here is that at the time that the Constitution was written, the rule in Anglo-American jurisprudence, and that's what's important here, Anglo-American jurisprudence, not international law, The rule in Anglo-American jurisprudence was that if you were born abroad, you were natural born only if your father was a citizen. Now, some people will stand up and say, well, that's outrageous. What about equal rights for women and so forth? For the most part, the Constitution was gender neutral, which is good. But that doesn't affect the fact that you have a founding era definition here. There have also been some folks who have said, well, that difference will never survive the Equal Protection Clause of the 14th Amendment. Under the Equal Protection Clause, the government is required to treat men and women equally, but the Equal Protection Clause only is targeted at state action. It doesn't deal with federal definitions.
Yeah, so I think a really simple way to say it is when it comes to citizenship, it's about parentage and or location. So you're a citizen if your parents were citizens, or you're a citizen if you were born on U.S. territory.
Well, you're a statutory citizen. In other words, Cruz is a citizen by reason of statute because he's the child of a citizen mother. The question is not whether he's a citizen. The question is whether he's a natural-born citizen.
Right, and when it comes to natural-born citizen, the difficulty is the only standard we have is an old one that most people would find repulsive now, and that standard was that your citizenship, your natural citizenship, could only come through the father.
If you were born abroad.
And I think that if this were to go to the Supreme Court today, it'd be really hard for them to rule that way.
But the problem...
Here's the other thing. It is true that some of the justices on the Supreme Court would absolutely shrink from applying what we call the patrilineal rule, the rule that it only comes through the father. However, you've now got progressive or liberal law professors out there spinning theories about why Cruz is not a natural-born citizen for other reasons. Now, I don't buy those theories, but they provide a fig leaf to a liberal justice who might want to rule against Cruz, but not on patrilineal grounds.
Well, but would they have the ability to do that retroactively? In other words, when he filed to become president, this law was extant, but now they're going to change it. Is it possible?
There's no law. There's no law extant right now saying he's natural born.
Okay.
There's only a law saying that he's a citizen.
Okay.
The precedence is English common
These
law.
lawsuits that have already been filed are certainly not retroactive. Alan Grayson, a rather repulsive congressman from Florida, has indicated that if Cruz wins the nomination, he will file an additional lawsuit, and I'm sure his will be well funded.
Yeah, we're going to come right back. Dave and Charles, you're going to be on with Rob Natelson when we come right back. If the lines are full, as they are right now, you can make your comment on our Facebook page. Talkback rolls right along, brought to you in part this morning by Nissan and Hyundai of Missoula under new management, offering rebates, discounts, and 0% financing on a huge selection of inventory, and by Selway Armory on Stockyard Road. More guns and ammo than anyone in Missoula. The best prices in Montana, Montana's premier firearms dealer. John King, Rob Natelson on the phone.
All right, we got a quick question from Katie, then we're going to callers. And Elena, I will get your question in. I'm just doing this question ahead because of the theme. Katie wants to know, what about Rubio? He was born in Florida in 1971. That's a key point in this discussion. And his Cuban national parents didn't receive U.S. citizenship until 1975. He is an anchor baby, in other words. So, Rob, is he a naturalized citizen or not?
Rubio has no problem, period, end of discussion, absolutely. The U.S. Supreme Court decided in the 1890s that the child of foreigners who give birth in this country is a citizen, at least if the foreigners are here legally. So it doesn't matter that they were citizens of Cuba at the time he was born, if they're here, certainly if they're here legally, possibly if they're even here illegally. We don't know yet because the court hasn't dealt with it.
Isn't that something?
But if they're here legally, any child they born here is natural born, and that's absolutely settled law.
Isn't that something else that Donald Trump said he wants to change with anchor babies?
I don't follow all of Mr. Trump.
He said, well, as soon as the judge signs the bill and makes this law for Donald Trump, he said that before, by the way.
Okay.
He's got his division of power confused.
Yeah, just a little. All right, I'm sure there'll be a clinic when he wins the White House. The first week will be, okay, here's the Constitution, read it, get to know it. Okay, Dave, you're on with Rob Natelson. Go ahead, sir.
Yeah, good morning. I was wondering about the laws on torture. Now, Trump has said that he wants to change the laws on torture or adjust them. And And I've heard that Cruz would probably have to do the same if he wants to follow through on his plan also. And I'm wondering what you feel about that.
I'm really not. I can tell you how I feel about it. I don't like torture, but I will also say I don't like terrorists. But that how I feel is really irrelevant because I'm a constitutional scholar. The law in this area is a completely different area of specialty, and it's not something that I can talk about. I mean, one of the commitments I try to make on this show is to talk about what I know, not what I feel.
So, in that sense, are you saying that the Constitution doesn't say anything about torture?
Well, the Constitution does indirectly. First, it prohibits cruel and unusual punishments, and that applies after conviction. So if somebody is convicted of treason, let's say, it would be a cruel and unusual punishment to draw and quarter him, which involves a form of death that implicates a lot of torture. Then there is the provision of the Fifth Amendment against coerced confessions, and that also is directed partly at the use of torture. But the Constitution never uses the word torture.
Okay, let's get back to the phones. Get one more call in before we take a break. This is Charles. Charles, you're on with Rob Natelson. Go ahead.
Hi, Charles.
Hi, Rob. Rob, this is a general area. I hope you can give us a little enlightenment on it. We've had, first I'm talking about immigration, and, you know, the liberal Merkel of Germany position kind of is that there's a generous invitation to immigrants without really questioning them very much, and just kind of keeping things sort of quiet so the problems and so forth won't excite the public. Now, recently, our Ravalli County commissioners here took a little different position in that they were inputting a letter about this. Missoula was taking some refugees in, and just opening it to the public generally on the position really of helping the UN with their refugee problems. And I would like to say this. Obama said he's the one who decides how many refugees are taken in. Can you give us a little insight into this general thing? Is it legitimate for the people and the states to be concerned and to express that through government and try to regulate this?
Okay, well, we're gonna have him answer that when we come back from the break. So hang on, Greg. We also have Greg on line 3 and one line open now. It's 721-1290. We'll talk about immigration when we come back. All right, we're back on Talk Back. Our guest this morning, Rob Natelson from the Independence Institute. Okay, we had a Charles wanted to ask about immigration and what power the president has in that constitutionally.
Specifically refugees,
Yeah.
right?
Well, the question of immigration generally is mostly not a constitutional one, it's a policy one. The United States in our history has gone from completely open borders, which is what we had in most of the 18th, 19th century, to very tight restrictions, which is what we had in the 1970s. And the federal government has the power to do either one. I mean, the Constitution gives the power to Congress to make laws pertaining to what's called the law of nations. And we know from the founding era sources that immigration policy is part of what they meant by the law of nations. There are some constitutional issues around the edges. For example, the courts have found, I think probably correctly, that President Obama is overstepping his authority by trying to, in effect, change immigration laws. You know, that the power over immigration is given to Congress, not to the president. So he's apparently been trying to change the congressional law through the use of executive orders. So that's certainly a constitutional issue.
And,
Also, an interesting constitutional issue came up when Trump said he wanted to temporarily ban all Muslims from the country, and the question arose: was that a violation of the First Amendment, freedom of religion? And the answer, which I investigated to my surprise, is actually no. The courts have been very deferential to the federal government, have acknowledged the federal government's power to exclude anybody for any reason, including that person's personal beliefs. But again, that's a decision for Congress, not the president. Mr. Trump and others, including Obama, need to keep that in mind.
All right. We got a caller, Greg, on the line.
Yes, we do. Greg, you're on with Rob Natelson. Go ahead.
Yes, I may have already
Hey,
had
Greg,
this question.
Greg,
Yeah,
you got to turn your radio down, man.
I don't have the radio on.
Oh,
we're
okay.
getting feedback.
Go ahead.
Go ahead, Greg.
Okay, I'm sorry. I just want to ask now, I understand from another conservative talk show that Cruz's father was an American citizen before he went to Canada and became a citizen.
No,
Is that right?
he had lived in the United States, but he wasn't an American citizen.
Okay, well,
He had lived in Texas.
All right, so then they got that wrong.
Yeah.
Okay.
Okay.
Because I just wondered whether that made a difference. So.
Well, if he had been an American citizen, yeah, it would have made all the difference. I mean, a great example is John McCain. John McCain was born in Panama, but he was born of an American citizen honorably serving in the United States Armed Forces. If an American citizen is abroad, then that person has always been, a male American citizen has always been recognized as someone who can communicate natural-born status to his kids. I saw on MSNBC a Harvard law professor who said, well, the only reason McCain, and this Harvard law professor was arguing that Cruz was not natural-born, he said the only reason McCain could communicate natural-born citizenship to his kids is that he was actually serving in the military at the time, and you have to have been a man serving in the military or serving in the diplomatic corps. That Harvard law professor got it wrong. It didn't matter why you were overseas. If you were an American citizen or a British subject and you were overseas and you were not engaged in treasonous or felonious activities, you could communicate natural-born status to your kid. And that's probably the way the founders understood it. But at that time, mothers could not.
A question from Facebook. Yeah. Elena wants to ask about libel. She says, please ask Rob to explain his incident with the Montana human rights nitwits, calling him, quote, anti-Semitic, end quote, when he was running for office. You got a little self-loathing there, huh, Rob?
That's hilarious.
She says that the same, quote, nitwits were branding the Montana anti-refugee group with the same undesirable name.
Yeah, the Montana Human Rights Network probably ought to be a liable descendant, because what they do is they go around and make, they do hit pieces on people they don't like. At the time, this was 1993, and I was heading Montanans for Better Government, and Elena was involved in that. And they came out with a press release darkly hinting that they were that Montanans for Better Government was somehow anti-Semitic and that we were cooperating with anti-Semitic elements throughout the state. They were apparently unaware that I was Jewish. And so I issued a statement saying that that Montanans for Better Government is opposed to discrimination based on race, religion, ethnic group, and so forth, including opposed to anti-Jewish sentiment, and that would include the background of the founder.
So when you're done laughing, you can make that point.
And what was funny about it is the Montana Human Rights Network, their quote research is extremely sloppy, and this is a great example of it.
Okay, we're going to come right back. Emmett and John, we'll get you guys on in a moment. We have a 1-minute timeout, and rapidly running out our time with Rob Natelson. We'll be right back. All right, we're back on Talkback 721-1290. I want to get as many calls in as we can. Rob Natelson, of course, our constitutional scholar from the Independence Institute. And let's get Emmett on. Emmett, thanks for holding. Go ahead.
Oh, thanks for taking on the call. Well, Rob, a couple of constitutional questions about the election and what they're trying to do to Donald Trump, I think it's unconstitutional, but I'd like to get your opinion. I've heard theories in the media that even if Donald Trump does get the necessary delegates to be the nominee, fair and square, that there are some in the Republican Party that would deny him those delegates and say, no matter, even if the people wanted him and voted for him, we're going to give it to a Mitt Romney and somebody else, and Donald Trump, he doesn't exist. Or they want the other candidates to hang in so that it will steal delegates away from Donald Trump. If they can keep hanging in, they want to sabotage his campaign. Is this legal, just to throw away the votes of the American people that really want Donald Trump and say, we're going to choose somebody else for you? Because it's like they're throwing away the Constitution, and even though Donald Trump is playing fair and square, they're not. I'd like to get your opinion in a constitutional way about that.
To be fair, if you're already voting for Donald Trump, you've already thrown the vote away.
Well, look,
according to John,
the merits of Donald Trump don't answer Emmett's question. So let's answer it. The way the delegates operate, this is largely controlled by state law. But generally speaking, in most states, if you voted for Donald Trump delegates, those delegates are going to be committed to vote for Donald Trump, and there's no way that the party leaders can change that. Now, if Trump doesn't get a majority on the first or the second vote, okay, and you move into the position where the brokered convention begins, generally those delegates get freed up. It depends. In some states, they're committed to go with their candidate to the very end. In other circumstances, after the first or second ballot, and I don't recall what the Montana rule is.
Sorry, what was the question?
After the first or second ballot, they can vote for someone else. And historically, if the front runner doesn't get a majority early on, generally the front runner's support begins to erode, and people then start horse trading. So it's to the benefit of Donald Trump or any front runner to try to seal up a majority going into the convention, and then everything that people want to do to you becomes irrelevant.
Yeah, a lot of people. So there's to win the nomination, you need a majority of votes. That's 1,237 votes, because the party has built a system so that whoever wins will have a majority of support. They predicted in the past that there might be a situation where you have 4 or 5 people that choose not to bail out of the race, and where you have a divided field where no one has a majority.
That's right. And some strategists, some anti-Trump strategists, are saying that rather than everybody uniting behind one candidate who's an alternative to Trump, that you actually keep everybody in the race, because Kasich can pick up Ohio delegates, and maybe Rubio can pick up Florida delegates, and so forth, and so that prevents Trump from collecting a majority. If he goes in there without a majority, unless he's very, very close, if he goes in there without a majority, my guess is he won't be the nominee because the party leaders are so concerned about him. And I have to say, Emmett, are justifiably concerned. And people who know me know that I'm not an establishment guy. I mean, I've fought the establishment in the Montana Republican Party a good deal. But I think this particular nomination is deep trouble.
Yeah, the question that I think a lot of people have, like Emmett, is, has the party changed its rules or done anything different to try to trick the system because Donald Trump is there? And I think the question at this point, at least, is no.
No, they haven't tricked the rules, and they had better not trick the rules, because if they do that, then they're almost guaranteeing a third-party run, and they're guaranteeing defeat. And I don't think, frankly, that Hillary Clinton is any better than Donald Trump. I mean, she has very, very, as you know, very severe baggage. And if she were a Republican, I don't think she would be a viable candidate, because I think the Republicans tend, this is a generalization, but I think a fair one, I think the Republicans tend to be a little bit more sensitive to scandal than the Democrats are.
All right, let's get John on the line. John, thanks for holding. You're on with Rob Natelson. Go ahead.
Okay. A superior resource on which the founders drew, I believe, for the writing of the Constitution would be in the Bible. And in there, with regards to the law of marriage, it says, when Adam was presented Eve, that you are now bone of my bone and flesh of my flesh. It doesn't say bone of one another's flesh. So I think that there is precedence for the consideration of the paternal tracing of birth. And so I think that given that marriage definitions are on the rocks as it is, and fathers' rights should be stood up for, that we should respect the founders, including that it be traced through the father.
Okay. Thanks for the
Okay,
call.
but
Interesting.
I mean, the
Interesting.
Bible certainly informed the founders. There's no question about that. We have to be careful, though. The Constitution was not meant to be a statement of canon law or religious law. It was meant to be a statement of secular law. And in the course of writing it, the founders adopted most of their definitions from the secular law, and the term natural born was a great example of that. They recognized, since this was a matter of positive law or secular law, they had to make compromises. So they didn't always follow the biblical definition of things.
Hey, Rob,
Rob, we got a question from...
I think the caller's point is that if you're interpreting terms in the Constitution, you want to go to the founders' reference points, and the Bible is certainly a very important reference point to them, and that's absolutely a legitimate point.
Okay, we have about a minute left.
One more caller, real quick.
All right,
Rob.
real quick. Mark Johnson, Ambassador Mark Johnson, you're on with Rob. Go ahead.
Oh, hi, Professor. It's great to be with you. I joined you late. I just heard you were on. A question about the Constitution, Article 2, Section 2, the powers of the Commander-in-Chief and the creation of a national navy. I've always had the impression that it was the war with the Barbary pirates in the early days that directly influenced the framers when they went to Philadelphia. And I wondered, is there any truth to that assumption?
I don't. First off, it's an honor to talk to you, Ambassador.
Thank
you. I don't think so. The war with the Barbary pirates really exploded on the scenes after the Constitution was written. The power to form and maintain a navy was simply part of the acknowledgement that the government might be involved in war, and we would need a navy to defend our shores.
All right. Thanks, Rob. You've been great, as always. You can pick up his book, The Original Constitution, What It Actually Said and Meant. Tomorrow, we'll have Ryan Zinke on for a little bit. We'll also speak with people that live on Mary Avenue or dealing with that mall expansion, see how they like that.
I get to drive to Montana today.
Amen.
Yay.
All right, thanks, Rob. All right, have a great day, everybody. Enjoy the sunshine.